Okay, hello and welcome to the Legal Aid Agency Help Us Say Yes webinar series. This one is covering the initial applications for family legal aid from the merits perspective. As part of the webinar, we're going to be providing some guidance on the initial application for legal aid and what the requirements are from the agency, what information to include in the statement of case. We'll be covering the evidential requirements, covering domestic abuse and child protection issues, some issues on managing live cases, and then at the end, some hints and tips. My name is Peter Reid. I'm one of the technical leads on the merits side of things for the agency, and I'll be joined by my colleague Stephen Spittlehouse, who is also technical lead. And the purpose of the webinar is, by the end, hopefully you will have an understanding of the right information to enable us to make a decision first time, how to make it easier for that decision to be a grant of funding, what issues to address when submitting the application, and what information we need from you, and the common problems encountered with the evidential requirements for private law family matters. So I'll start off with a section on the initial application for legal aid, looking firstly at matter types, proceedings, and scope limitations. If you can remember that public and private law matter types cannot be mixed on our CCMS computer system, and they are unable to go on the same legal aid certificate, with one exception, and that's in the case of Special Children Act proceedings. In those circumstances, if applications that would normally be private law matters, for example, child arrangement order, are being heard within care or supervision proceedings, then they can be added to the certificate as related proceedings. So you can add on other aspects of a case relating to children matters. They are being heard together or as an alternative to the care order. Other hints and tips: when using delegated functions to grant emergency legal aid, please ensure that you add appropriate limitations to both emergency and substantive applications. We frequently see situations where either no scope limitations at all are applied to the substantive matter, or you just leave on the emergency limitation, and that means we have to add what we consider to be the appropriate substantive limitation. But if that's not what you wanted on the certificate, it then puts you and us to further work when you have to come back and query it with us. Sticking with delegated functions, if you are delegating for a higher costs limit than the default £2,250 limit, please make sure you include the reasons for that increased limit in the statement section of the CCMS merits report. You are asked to provide supporting information, but if you can include it in the statement section, that makes sure that the caseworker dealing with the application gets to see it and is aware that a higher limit has been delegated. Moving on to the different types of delegated functions application, I'm sure you're aware that they can be submitted as either a single stage application, where both emergency and substantive elements are submitted together, or it can be submitted as a dual stage application, where you send in the emergency application, which we consider, and then once we've granted that application, you're then able to submit your separate substantive amendment. And the dual stage process may be more appropriate when you anticipate there is going to be a need to further delegate before the agency can make a determination on the emergency application and before you get a chance to submit the substantive application. If you are submitting a non-delegated functions emergency rather than granting the application yourselves, please explain why delegated functions have not been used. That may be because you have concerns about the merits of the case, or the client has complex financial circumstances and you want us to make a decision on that application first. But if you explain that in the application, it will avoid, hopefully, a situation where we simply refuse the emergency request saying you have delegated functions to grant this and you should be using those powers. If you are submitting a non-delegated functions application, a reminder that you have to consider the interests of justice test contained in Merits Regulation 46. And the basis of that test is, firstly, do the services being sought need to be provided before there would be time for the agency to make a full determination on a substantive application? And what is the seriousness of the consequences if those services are not provided on an emergency or urgent basis? So what impact will it have on the case? And obviously in family matters, we're usually looking at what risk is there to the client if, or a child of the relationship, if an order is not obtained on an emergency basis. So that brings us to the end of the initial application section, and I'll now hand over to Stephen, who will take you through the statement of case and supporting documents section.
Hi, my name is Stephen Spittlehouse. As Peter mentioned, I'm also a technical lead. This session, we are going to be talking about the statement of case and supporting documents and what information we require to help us get it right first time. Domestic abuse applications within the statement of case or merits report set out the history of the previous incidents together with the most recent incidents that have led to the current application. If there's been any delay in seeking an injunction, so for example, the last incident was in March and the application has only just been submitted today, please explain the reason for that delay and why you consider the court will still make an order. The question of proportionality needs to be addressed, so explain why alternatives such as sending a warning letter or notifying the police are not appropriate. And if the police have been notified, explain why insufficient protection is currently in place and why an order is still required. Similarly, if the opponent is subject to bail conditions, explain why your client separately requires a protective injunction and why those bail conditions aren't affording proper protection. If you are representing a respondent, please set out a detailed response to the allegations. A blanket denial simply saying the client denies the allegations isn't sufficient really, and it's less likely to end in a grant. Explain any effect the order will have on other matters between the parties. So for example, if there's any child arrangement orders ongoing and how any order would impact on those. And explain why the matter cannot be settled by way of an undertaking and how any order will impact on the client. Private law, children and finance proceedings. Ensure you have the relevant evidence, be it domestic abuse or child protection evidence, to bring the proceedings into scope at the point of submitting the application or at the point of delegation. If representing the applicant, provide copies of any correspondence with the other side or the solicitors with a view to settling matters and avoiding litigation. If you're acting for the respondent, provide copies of the application made by the applicant and any orders made to date, plus any expert evidence obtained, such as CAFCAS reports, Section 7 reports, etc. In financial proceedings, such as ancillary relief, set out the details of the assets in dispute, and if the assets are abroad, how they can be enforced. In trust of land proceedings, tell us how the client has acquired an interest in a property, whether they're joint owner, they've contributed the purchase price, or have paid the mortgage or utility bills. In all cases, we need to set out the circumstances of the case, the issues in dispute and any steps taken to reach a settlement. Public law children cases. If the client is seeking to be joined as a party in care proceedings, please set out their involvement in the child's life and the role they seek to play in the future. Provide any assessments of the client, and if any unfavourable reports or assessments, tell us on what basis those reports and assessments are to be challenged. If the client is seeking discharge of care order, please set out when the order was made and what changes have been made since the original order, and if possible provide us with a copy of the order. Whether any approach has been made to the local authority and the outcome of that approach, and the basis upon which you seek to persuade the court an order is no longer required. If you seek contact with a child in care, set out what approach has been made to the local authority, how contact has progressed to date, and what additional contact is required. That is the end of that section. I will hand you back over to Peter.
I'm just going to go over some of the more common problems and issues we encounter when dealing with the evidential requirements required to bring into scope private law, children and finance matters relying on either domestic abuse or child protection evidence. So just to give an overview, first of all, the requirements are set out in paragraphs 12 and 13 of Part 1, Schedule 1 of LASPO. And it's just a reminder at this point that it's not a requirement for legal services provided under paragraph 10, where there has been an unlawful removal of a child of the relationship, or where there is a threat to remove that child from the UK. Applications that don't fall within the definition of paragraph 10, unlawful removal, will still require gateway evidence. There is guidance on the evidential requirements available on the gov.uk website under evidence requirements for private family law matters, and that sets out in detail the nature and format of the evidence that we can accept under either paragraphs 12 or 13. While there are no longer time limits imposed on the evidence provided, and therefore it's not a prerequisite for that evidence to be dated, it does become an issue in circumstances where you have delegated functions to grant an emergency certificate. In that situation, we do need to know that you have the evidence with you before you delegate and before you make that determination. So in those circumstances, if the letter or document that you have isn't dated, we are likely to ask for confirmation as to when it was received. And one of the requests we want to make is that you do not answer yes to the cross-border disputes question when submitting an application for legal aid, because that then routes you away from the other questions about supporting evidence, and it can be quite useful for both yourselves and us to be able to identify what type of evidence it is you're relying on and which part of the requirements you consider that piece of evidence satisfies. So moving on to the proceedings for which evidence is required. Again, these are set out in paragraphs 12 and 13 of Schedule 1, Part 1, and they are also listed in Regulation 33 and 34 of the Civil Legal Aid Procedure Regulations. One thing I want to do today is draw a distinction between those proceedings which are brought into scope on the basis of domestic violence evidence and the differences with those that are brought into scope purely on the basis of child protection evidence. Paragraph 12 is much more widely drawn and lists virtually every family enactment that we're likely to come across in the private law arena. And that means that if you have domestic violence evidence that meets the criteria, it is likely that that will be able to bring into scope virtually any private law, children or finance matter. However, if you are relying on child protection evidence, the list of proceedings in paragraph 13 of Schedule 1, Part 1 is much more restrictive and only covers child arrangements orders, special guardianship orders, specific issue and prohibited steps orders, orders under section 33 and 34 of the Family Law Act 1986 for disclosure of a child's whereabouts or return of that child, and finally an order under section 4 of the Children Act in relation to the removal of a father's parental responsibility. Anything else that doesn't fall within that list of proceedings cannot be brought into scope purely on the basis of child protection evidence, and you would have to have domestic violence evidence instead. Moving on to some of the issues we encounter with the evidence itself, a reminder that a letter from an appropriate health professional must confirm that the injuries or condition that the health professional has identified were considered to be consistent with those of a victim of domestic abuse, and it must be an affirmative statement. It shouldn't be any sort of equivocal phrase such as could be or possibly. Similarly, letters from organisations providing domestic violence support services, they have a number of requirements, and they must include that the person writing the letter has made an assessment, like the health professional, that the client is a victim of domestic abuse. The letter must describe the specific matters relied upon in order to reach that judgment. The letter needs to provide a description of the support provided and also a statement of reasons as to why the client needed that support. We frequently find that we are being sent letters which omit one or more of those elements, and as a result, we aren't able to accept them. Which neatly brings me on to the next part of the session, which is, wherever possible, can you encourage the organisations that you are dealing with to provide the supporting evidence on the template letters that are available on the gov.uk website? And then before uploading those letters, can you double check against the requirements to make sure that the letter contains all of the required information and the format of the template letter has not been altered by the organisation that produced it? Having said earlier that there were no time limits on evidence anymore, there are still a couple of pieces of evidence that are time sensitive, and they are in relation to an arrest for a relevant offence or ongoing criminal proceedings. The evidence of the arrest is only valid whilst the investigation is ongoing. So if the police conclude their investigation and take no further action, and that has happened before you submit your application for legal aid, that piece of evidence is no longer valid and you'll need to provide something else. Similarly, ongoing criminal proceedings, if they conclude either by way of being discontinued by the CPS or if the other party is acquitted, then that evidence would no longer be valid and you would have to provide alternative evidence. And again, linking back with the request for you not to answer yes to the cross-border disputes question, that will route you towards questions that get you to identify the nature of the evidence that you're relying on. And some documents can satisfy multiple elements of the requirements. So whichever one you consider it satisfies, answer yes to those questions. And that way we'll be able to compare the evidence with a number of different paragraphs of the requirements to see whether or not it fits the guidance or not. So that brings me to the end of the evidential requirements section. So I'll hand you back to Stephen for the final hints and tips section.
final session is going to deal with a few hints and tips. It's some common issues we've found through phone calls to our customer service team or case enquiries. First one, deprivation of liberty applications. If an application for a deprivation of liberty order has been made by the local authority under the High Court's inherent jurisdiction, where the local authorities seek to place restrictions on the liberty of the child in their care, if the application is to be heard within ongoing care proceedings, then the current care certificate can be amended. Unfortunately, there's no preceding wording for inherent jurisdiction applications under either the SCA or public law matter types. So any amendment can be made by adding an additional hearing limitation to the existing proceeding in free type and appropriate wording, such as all steps up to and including the hearing of an application under the inherent jurisdiction of the High Court for a deprivation of liberty order. If the application is timetabled separately from the care proceedings, or it's even after the making of the final order, then a means of merits application under the High Court matter type will have to be submitted, selecting one of the inherent jurisdiction proceedings. Injunction and children proceedings, as you no doubt aware, you can delegate for a protective family injunction and at the same time delegate for a Children Act proceeding, relying on the injunction to bring those proceedings into scope, so long as both applications were made at the same time and orders obtained at the same time. With any application, provide the applications and orders, and if the orders aren't available when you submit the application, confirm that the applications were made at the same time in the statement and the marriage report, and you did get the orders. Domestic violence injunctions, was mentioned earlier, but further hint and tip, although it is acceptable to submit the client's statement to court in support of an application, we still need to know whether a warning letter was sent or the police were involved, and if not, why not? So can you please provide that information in a marriage report or even in a separate statement? If it's not provided, it's likely we will ask for details before we're granting. If you're applying for an amendment to go to final hearing, please upload the order listing the case for a final hearing, together with any expert report, such as a CAFCAS report or a Section 7 report. And if any report is negative, a statement setting out why representation is necessary. When applying for a cost increase, provide a breakdown of the costs incurred to date and an estimate of the costs to be incurred with details of the future work, so we can determine whether any cost increase is justified. That concludes the hints and tips section, and it also concludes the Help Us Say Yes webinar.